Good afternoon, everybody, and thank you for joining us for the 5th webinar today in ConMass-Elkerry's 2018 MSHA webinar series, where we'll be discussing responsibilities and regulations with independent contractors on site. So this is going to cover not only some of the perspective from the mine operator and the production operator, but also for those contractors, some best practices and items for you to incorporate moving forward. As always, I am Nick Scala. I am the chair of the MSHA practice at ConMass-Elkerry. Here we have OSHA and MSHA practice where we work with companies around the country in litigation in front of the Federal Mine Safety and Health Review Commission, as well as in front of the Occupational Safety and Health Review Commission. We work with companies through accident investigations, compliance audits, and assistance in managing those and litigating before the respective federal bodies. Today we're going to cover several things, and when we're talking about independent contractors, I think some of the biggest questions, the most frequent questions I get are, who is a contractor for purposes of training? What are the requirements of that company on the site, as well as what are the requirements of the production operator when that company is on the site? So we will start off by defining what is an operator and also what is a miner, and for purposes of needing training. We will take a look at who's responsible on the site, as well as the records that we have to keep and who has to keep them, and who is in charge of completing what training. So those are the outlines of what we're going to cover today. We have a number of slides to get through, so I will be moving through them a bit quicker than normal. But again, I think we're going to be dealing with a lot of statutory language at the beginning, and we'll be able to move through those pretty quickly. But again, if there are any questions, just feel free to enter them in the chat function, and I'll address them at the appropriate time. So when we talk about independent contractors and MSHA, we have to look at the two distinctions. And we can't say, or we shouldn't say, operator and independent contractor, because that definition is inclusive of both when we say operator. When we're talking about these for today, and when we're dealing with MSHA, we want to look at it in terms of the production operator, as well as an independent contractor. So the production operator, as you might expect, is that company that owns, operates, lease, or controls or supervises a coal or other mine. The independent contractor is any partnership, corporation, or association that contracts to perform services at that mine. So there is a distinction between the two. We want to keep that in mind because as we get into the next slide, or I'm sorry, not the next slide, but we'll look at what is the definition of an operator. And the definition of an operator is both independent contractors and production operators. And that is important for liability purposes, which we'll cover, but for the beginning purposes, when we're looking at how we're going to define the entities in this PowerPoint and in this presentation, we're going to look at, is a company a production operator or the independent contractor? Both of them are going to be considered operators in the eyes of MSHA, and so we'll look at it in that lens moving forward. So when we're looking at what is an independent contractor and what requirements do they have, we also are going to be looking at, are the employees of the independent contractors miners? And we're going to look at this both from the perspective of Part 46 and Part 48 because it's slightly different, and depending on your operation, one of those two is going to cover your training requirements. So we can see when we look at the definition of a miner, and this is under Part 46, that it includes any operator or supervisor who works at a mine, is engaged in mining activities and mining operations. It includes independent contractors and employees of contractors who are engaged in mining operations. So that is an important distinction because even though you may not be specifically engaged or employed by a production operator, you could still be considered a miner. And as we'll talk about later, that means enforcement is possible. That also means that there's requirements in terms of compliance for training. It also goes to show us in this first set of definitions that a construction worker is also a miner if they are exposed to the hazards of mining operations. And that is a distinction that we're going to cover between Part 46 and Part 48, because Part 48 has a great deal more nuance to it when it comes to what entities or what persons are covered. Part 46 is a bit more overarching, and what we're looking at there is the construction worker who is exposed to mining hazards. Also in the definition for Part 46, it specifically excludes a class of individuals that might be on site. And this is scientific workers, delivery workers, customers, including over-the-road truck drivers. And the reason that is an important distinction is because there is a difference between the training requirements of a miner and just anyone else that comes on site. You are going to be required to provide hazard awareness training for anyone that comes on site. That does not mean, though, that that person is required to have comprehensive miner training. The bottom paragraph on the screen right now is a statement that causes a lot of confusion in the mining industry because it's not enforced consistently between the districts, between field offices, even between inspectors. There's a lot of questions about what is frequent or extended periods of time. But for the purposes of training, if an individual, an independent contractor, does not work on site for frequent or extended periods of time, they are required to have the hazard awareness training, but not required to have comprehensive miner training. So those are some important distinctions. Along with that, we talked about in the last slide that construction workers are exempt unless they're involved in or exposed to the hazards of mining operations, and that the definition of miner included those individuals involved in mining operations. So for the purposes of Part 46, they give us a list of what specific activities are going to be considered mining operations. And we can see it's mostly straightforward in terms of extraction, milling, crushing, mine development, drilling, and blasting. These people are obviously going to be miners. They're engaged in the mining and milling process. One area that tends to give people issues, just based off of the language in the last slide, we saw that over-the-road truck drivers are not considered miners for the purposes of training. Here we see in the bottom right-hand corner the associated haulage of materials within mines from these activities. So what that means is that if you have truck drivers who either are employed by your company or a subsidiary, or you hire them through an independent contractor to haul material from your site to customer sites, if by any chance you switch up their job duties to haul material from one side of the mine to the other, those truck drivers have now crossed the threshold from being non-miner independent contractors for training purposes to miners. I've seen a number of these citations recently, and it is where an over-the-road truck driver has maybe given alternate duties or signed a contract to haul material from one place on a mine to the other, and in doing so, they have changed to a miner. And so in this case, if someone is involved in the listed items on the screen right now, they are required to have the comprehensive new miner training, or if they're an experienced miner training, they'll have to be retrained accordingly, and they'll have to have their annual refresher and so on and so forth in order to be maintained in that status. But this is a question that people often ask, what is considered a mining operation? This is the list that MSHA has produced. We also had been just discussing frequent or extended periods of time, as there was that, again, exception to the regulation where it said maintenance and service workers are not required to have comprehensive training if they are not on site for frequent or extended periods of times. Now, this definition will be slightly different when we're dealing with Part 48, but for Part 46, we see the guidance in the MSHA Program Policy Manual. And that Program Policy Manual, if you have not looked at it, it's a very good resource for looking at guidance and how MSHA is going to interpret their regulations, or what they expect in terms of achieving compliance with those regulations. So Unfortunately, as is typically the case, these definitions leave a bit to be desired, especially when we're looking at the definition of frequent exposure, because that is just defined as a pattern of exposure to hazards at mining operations occurring intermittently or repeatedly over time. So this is somewhat of a field test. We have to look at the collection of times that an independent contractor is on site to determine, has this person been on site and exposed to hazards on a repeated or frequently repeated time. So I have heard some MSHA personnel say that can be once a month. Others say it can be once every 6 months, and that is intermittent enough. So you have to kind of look at the collection of what those people are doing, how long they are on site, and the activities that are being performed around where they're working. Because again, the mining operations and it being exposed to the hazards associated with such are a primary element of that definition. So, you know, I commonly tell people we have to look at what we are going to be having the person perform and where that's located and how often that is going to be performed. If it's someone coming on site, maybe it is changing out porta-johns or cleaning porta-johns, that's a commonly requested clarification. It depends where they're going to be doing so. Are they going to be exposed to mining hazards in that time frame? Now that is an instance where you're probably going to have the frequency satisfied, but again, it also has to look at the hazards of mining operations, how long they're on site, are there multiple, and where are they located at the facility. So the frequent exposure is more vague and leaves more to the interpretation than when we're looking at extended, because MSHA specifically says exposure to hazards at mining operations of more than 5 consecutive work days. Now obviously where the question comes about in this is what happens if it is 2 work days, take a day off, 2 more. If we're going in a situation where it is along those lines, or if it's for a couple days one week and then a couple days the next week, we're most likely going to be looking at the realm of satisfying frequent exposure. Another area where extended exposure gets called into question is if the independent contractor is working at multiple operations on consecutive workdays. And for the purpose of this analysis, from the production operator standpoint, we want to look at it from our operation. From an independent contractor status, we are probably going to be seeing it from the avenue of, if I have someone on site at a mine site for 5 consecutive days, they are going to be required to have that comprehensive new miner training. But again, it's an area where there is inconsistency in MSHA's interpretation of the definitions and their application of such for the purposes of enforcement. But when we're looking at it, when we're talking about ensuring that independent contractors have the requisite training on our site, we have to look at these time frames to see what they are going to be exposed to, where they will be working, and also how long they're going to be on site or how frequently. When we're talking about Part 48, as I mentioned, the definition is much more lengthy. It has more requirements in the regulations, and we'll see that later on when we also look at the required hazard training. But for the purposes of what we're looking at, I've highlighted several portions. And in Part 48, it says that any person working in an underground mine who's engaged in the extraction and production process, or engaged in shaft or slope construction, or regularly exposed to mine hazards, or is a maintenance or service worker employed by the operator, it is, and we see that term again, frequent or extended period of times, they will qualify as a miner. A condition and a somewhat difference between what we are looking at in here as definitions of a miner as opposed to Part 46, where we look more so at the hazards around, is there is an exception to Part 48 that if you are engaged in major construction projects which require the mine to cease operations, and I think that is obviously the most important part of it, the mine has to cease its operations, you are not subject to the miner training requirements, and you will not be considered a miner per those regulations. So we see that there is a bit of difference between the two. We also see, if we're looking at Part 48, For the purposes of hazard training, it is similar in that it includes the same class of persons that do not require new minor training but require hazard training when they get on site, and that is going to be delivery office or scientific workers, short-term persons that may be coming on and off site. Just like with a Part 46 operation, those people all need to have the hazard training and will require or will satisfy the definition of a minor for those purposes in Part 48. If we're looking at the frequent or extended periods of time, as I said, it's a little different in that they have the term in their program policy of regularly exposed. And that means for MSHA in this instance, either frequent exposure or which is exposure to hazards at a mine on a frequent rather than consecutive day basis, which is a pattern of recurring exposure, or extended exposure of more than 5 consecutive work days or both. So we can see when we're looking at that, it's not an either or. It's not a both situation. It can be either or, frequent or extended exposure, or both, a combination of the two. So we have to look at all of that information when we're making the evaluation of whether or not our independent contractors are required to have that comprehensive training, and whether or not, as an independent contractor, we need to have that comprehensive training in order to secure a contract and take persons on site. So a brief overview of the definitions of a minor, which I believe that most wouldn't think it is that difficult or that detailed of a review, but it is in these circumstances, and it does change between the Part 48 operations and the Part 46 operations. And while some operators, production operators, might have both facilities, just as some contractors might operate under both facilities, we need to know the differences so that when we transfer between facilities or when we have issues at either facility with regard to training or a lack of training, we know what those requirements are. So they are somewhat similar, but there's also distinct differences between who is covered. So one area that is of the utmost importance when discussing the regulations and responsibilities with independent contractors on site is talking about the Mine Act itself. And that's because the Mine Act itself was written as a strict liability statute. And what that means is that liability, or in other terms, being able to receive a citation, does not depend on actual negligence or intent to harm, but is the break of an absolute duty to make something safe. And in this case, both operators have an absolute duty to make the workplace safe under the Mine Act. And this is how we can get into the situation where a production operator is issued citations for conditions that were contributed to or created by an independent contractor, and similarly, an independent contractor in less frequent circumstances can be issued citations for a condition contributed to or created by a production operator. In sum, what this means is that MSHA can issue citations to both or either party. When we look at it, though, primarily this is going to be a direction in terms of enforcement that production operators can and will be held responsible in terms of receiving MSHA citations for the compliance or shortcomings of an independent contractor. So this is where we get this discussion really starts, in my opinion, because when we're talking about the rules and regulation, we're always talking about this ability of MSHA to cite both parties. And this comes out of a case called 20 Mile Coal, when a coal operation was cited for safety defects on an independent contractor's vehicle. Their service truck had a number of safety defects. MSHA identified these and issued citations, and they issued citations to both parties. And in doing so, the coal operator challenged the citations on the basis of that they were not in control of the vehicle. It was not their vehicle, and they were not responsible for it. And the commission fell back on this strict liability. And if you've ever argued a citation with MSHA, or you've ever gone into an informal conference with MSHA talking about the difference between your responsibilities and those of an independent contractor on site, you will probably have heard that term, strict liability, because that means that you can be issued the citation as well. Both parties can. This is also the basis through which a production operator can be issued a citation for not just minor independent contractors, but also those that do not qualify as minor, such as an over-the-road truck driver. Every year or every half a year, a citation comes across my desk that is for an over-the-road truck driver standing on top of the bed, trying to even it out or rake it down or put a tarp. And in those circumstances, it is rare that the over-the-road truck driver or their employer are receiving the citation. It is typically issued to the production operator, and again, that comes back to this strict liability nature of it. There's things we can do to distance ourselves from that in terms of training, in terms of signage, but if you're familiar with an MSHA citation, you will see when we're looking at the negligence evaluations, there are the options of reckless disregard, high negligence, moderate negligence, low negligence, and no negligence. And the reason that there is a no negligence option is because of the strict liability nature of the Mine Act, and because of the definition of strict liability up there, that regardless of finding of negligence or intent to harm, you can be held liable. So some overarching themes that we look at when we're making this review and we're talking about these topics is understanding kind of that core aspect of the Mine Act itself, which gives MSHA their ability to issue citations. So as part of that, not only is it in the Mine Act, not only is it the case, but in the program policy, MSHA specifically defines and addresses this ability to issue citations to either party. So we can see that, there is a number of discussions of the production operator, and it says that the overall compliance responsibility includes assuring compliance by independent contractors. And as a result, both parties can be held responsible or are responsible and can be issued regulations for violations of the Act, or citations. They call this an overlapping compliance responsibility, and it is up to the discretion of the inspector which party they want to issue those citations to. They can issue it to either the contractor, the production operator, or both. And in many cases, that's what you'll see, that both parties receive the citation, and in many cases, those citations are identical to each other. They're just issued to the other party, and that again goes back to this. So, to kind of hammer this home, we look at the program policy a bit more closely, and it talks about the specific situations where an act or a citation can be issued to a production operator. And if you are regulated by OSHA at all in your profession as well as MSHA, or if you are familiar with the OSHA regulations, there is a review for OSHA, which is not a strict liability statute, called the Multi-Employer Worksite Doctrine. And when you're looking at that, or when OSHA looks at that in terms of assessing a citation, they look at whether or not an employer is a creating employer, a correcting employer, an exposing employer, or a controlling employer. And those correcting, creating, exposing, controlling, those are all with regard to the work site and the hazard that was observed. So are you the employer who has employees responsible for creating the hazard or correcting it, or you had your own employees exposed to it, or were you the controlling employer in that you controlled the site and everything that went on at it? So that is an analysis that OSHA does in order to determine who receives the citation or which entity. And we can see here from the next slides that MSHA has a similar review, but it's with the lens of strict liability involved. So the first item is the production operator has contributed by either an act or an omission to the occurrence of a violation in the course of the independent contractor's work. So, the difference is not did you create it or did you control the area, but you have contributed by either an act or an omission. That means you either were an active party in creating the hazard or you did not, but it occurred on your site. So again, the scope of the Mine Act's authority is sweeping in this regard. Additionally, you have the second item, which is the production operator has contributed by an act or omission to the continued existence, so it was not corrected in a timely fashion or was not corrected quick enough. Again, then we have the production operators' miners are exposed, and the production operator has control over the condition needs abatement. And the fourth one is really a catch-all for the entire site because, again, control is based off of strict liability, and in this case, the argument that can be made that you should have control for safety and health purposes of anything that comes on site. And that is a frustrating prospect and a frustrating idea because we know that there is a disconnect between control over a vehicle that comes on site from an independent contractor that we do not have the ability to shut down or we do not have the ability to repair for other purposes outside of the Mine Act when we're talking about contractual or civil liability. But for the purposes of the Mine Act and what we're seeing here, you just have to have the citation occur on your site, and there can be a citation issued for it to either party. This is typically not something that is done every time a contractor receives a citation on your site, far from it. But if there is an accident or there is a serious injury and it involves an independent contractor, production operators can be fairly certain that they will receive a similar citation or similar citations or orders, depending on the circumstances of what occurred. So it is something that you need to look at, and this is one of the reasons why we want to make sure that we are vetting independent contractors, that our contractors are aware of our expectations from the safety and health policy side, as well as our expectations from a training perspective, and why we need to be careful about checking what is going on with the training and ensuring that it's being completed for those people. So most people ask questions about whether or not a contractor is required to have an ID, and what we have on the screen right now is a list of those activities which a contractor must file for an ID with MSHA. If they are performing any of these activities, they have to have a contractor ID. Now, any contractor that comes on a mine site can request one. It is not required. These are the activities that require a contractor ID. Additionally, even if a contractor doesn't have an ID, and they are not required to have one based off of the listed items or listed activities, they can still receive a contractor ID because MSHA has the ability to still cite those contractors, but they are, and at that time they will be provided a contractor ID. So for the purposes of being a contractor, for the purposes of ensuring that our contractors are handling or taking care of their MSHA compliance liabilities or responsibilities, if you have anyone coming on site to perform the listed items up here, so mine development, construction or reconstruction of mine facilities, again, there is that clause in Part 48 that says if the mine is ceasing operation, they don't have to have miner training, but that doesn't mean that the contractor doesn't need to have an ID. Demolition, earth moving is one that is commonly listed, drilling and blasting, material handling, and equipment service or repair are 5 consecutive days or more, which ties back into that frequent or extended exposure, which means that the person will have to have comprehensive miner training. So if we are soliciting contracts or fielding quotes for someone to come out and they are performing work as listed, you're going to want to make sure that they have a contractor ID, and if not, they are going to get one. And also, if they do not have one, or even if they do, you're going to want to ensure that these people have their own training plan, or that they are taking action to complete the requisite training based on what their employees will be doing on site. If you allow someone on your site who is not complying, an independent contractor who is not complying with the MSHA regulations, you as a production operator can still be held liable for those failures of the independent contractor. And that's what we were just talking about. So it's important to do this vetting. It's important to look at pre-qualification. Similarly, if you're an independent contractor, if you have all of this material and you have it collected and put together into a packet, you can put a lot of production operators at ease in the qualification process or the bidding process by providing your MSHA compliant materials as well as giving them that kind of information. If we are looking at this, I mentioned that all contractors must have their own training plan. If you are a Part 48 contractor, you can work under a mines training plan for the purposes of new miner training. It is something that you see, I think, less frequently in my experience in Part 46, and I also don't recommend it necessarily for either party, because we want to have that distinction that someone else, that contractor, is responsible for outlining what that plan will be. A major difference in the plans is that in Part 48 you need to have approval from the district manager, and that approval might need to be granted at intervals after subsequent review, so maybe it's every 3 years is a number that you commonly see. But it is nonetheless something that we want to make sure our contractors have when they're coming on site. And if we're a contractor, I would also encourage you to develop your own program so that you are aware of all the requirements in it, what you're signing up for. Also, you can have control over amending that if you want to change certain elements. Some operators or some independent contractors have Part 48 plans, and those allow them to work at both Part 48 and Part 46 mines. The same does not ring true if you are a Part 48 independent contractor. That does not cross over to Part 48 operations. So that is, again, something to keep in mind if you are fielding contractor bids or contractor qualification. You are going to have to check which plan that they are working on. Now, another important note in terms of compliance is that MSHA can request these and likely will request the training plan and the training documents when they come on site for an inspection. Training plans you have until the next business day to provide, but training records need to be provided to the MSHA inspector by the end of shift and they're requested. Okay, and that's an important element, and they do not field electronic records for the most part. If they are requesting them, they want them to be hard copies. So if you have them electronically, you're going to have to find a way to print them. And this is important because if you don't provide the records of training within the requisite time, what MSHA will do is they will issue a 104G order, which is a withdrawal order for untrained miners for the persons whose records have not been provided. So if we're a contractor, we want to ensure that we have those readily accessible for miners when they are out in the field so that we can provide them when they're requested by MSHA. Similarly, if we're a production operator, we probably want to make sure that our independent contractor is aware of that situation and aware of that requirement with MSHA so that if the need arises or if the records are requested by MSHA, we don't have our site shut down and we don't also open ourselves up to liability for having untrained miners on site. When we're looking at record maintenance, in addition to the training documents, an important element is the Part 50 injury and illness records. So if we have a contractor ID as an independent contractor, or if we are hiring an independent contractor who is performing that list of tasks and has a contractor ID, they are going to be required to maintain a Part 50 record-keeping log. and so that is going to be quarterly employment reports, as well as accident and injury, and any other requirements. If there is an accident, that you have to do an accident investigation report that will be available for MSHA when they request it. This also includes the 15-minute rule, or the immediate notification. All contractors are responsible for following those as well as the production operators. If we are a production operator and we have a independent contractor have an injury on our site, per MSHA guidance, you are also supposed to file a 7001 form. And what will happen is when those two forms, because the contractor should do it as well, are collected by MSHA at their record-keeping office, they will typically disregard the production operator's form. But if a contractor is injured on site and for some reason refuses to submit a 7001 or fails to submit a 7001 in a timely fashion, the production operator can receive a citation for that. So we want to ensure that we are communicating to our contractors that they have to file that form. We'll also submit or have our own to submit. I've worked with a number of companies that have operated under the impression that if the contractor files a form, you are not required to do so. And I have seen acceptance of that by MSHA inspectors. I think that the requirement is that both parties submit it. And I think if you want to be strictly adhering to those submission requirements, that's what you would do. If you, as a production operator, do not file a 7001 for an independent contractor, I would at least ensure that you are provided with and maintain a copy of what the independent contractor submitted, and keep that in your Part 50 records. Also, what some production operators do is they submit the identical 7001 that the independent contractor has submitted, but with obviously under their information. So those are several areas which you can go through it, but the important element is that you must ensure the 7001s are submitted, because if they are not, the production operator can be held responsible. Additional records that have to be maintained on site is the independent contractor register, and excuse me, that requirement has information that the contractor shall provide to the production operator, and then the production operator has to maintain that record. This is frequently something that MSHA inspectors request as soon as they get on site. It will also often drive where they want to go in their inspections in terms of wanting to hit the independent contractor sites first. That's pretty frequent. So we need to have this updated. There can be violations issued for it. It's typically a paperwork violation, but nonetheless, we don't want to get in that position. So make sure you get the required information from the contractor, which is pretty basic information, and then we keep that log updated. And that's the most important part, is we update the log as we go, especially if we're having a lot of contractors come in and out on a regular basis. In terms of pre-shift and workplace exams, this is obviously with the new workplace exam rule, this is going to continue to be a question of responsibility and who does it. I would say that production operators need to ensure that contractors know they're required to perform their own workplace and pre-shift exams. And pre-shift exams mean on mobile equipment. The workplace exams are obviously for the area in which their contracted services will take place. If production operator employees and independent contractor employees are working in the same area, both parties should be completing a workplace exam. If you're an independent contractor, you don't want to rely on the record of the production operator, and vice versa. We already have seen that there is that review in terms of, were you the creating, were you exposing? Although it is a bit skewed due to strict liability, it's still a question that is asked, and the inspectors will look at who had control over the area, who was in the area, what activities were taking place and by who. So if we want to make sure that if we have our employees commingling, that both are taking place. Now, one instance where that might not be applicable is if we are hiring temporary labor to come out and work, and they are working at the direction of production operator employees. If that is the case, then the production operator's record should be sufficient. But in any situation where you have contractor employees working independently from the production employees, both parties should be making a record if they're working in the same area. You should also make sure, if you are a production operator, that the contractor is performing those exams, because even if you tell them to, it's outlined that that is their responsibility. If they fail to do so, it can still come back on the production operator. So a bit of an area where you can have a paperwork headache, but nonetheless, some best practices moving forward. The workplace exam rule, I won't get into it too far because we could do an entire webinar on this, and we have, but it is now been effective since June. There was an enforcement hold, essentially, until October 1st, so we're now just a few days away from that being lifted, at which time, unless MSHA makes another announcement before then, enforcement on this new regulation will begin in earnest. So again, it applies to both parties. It includes the regulation or the change that the workplace exam for metal non-metal has to be completed before or as miners begin work in an area. There's also a requirement that miners must be promptly notified of any adverse conditions in their working area before they're exposed. And this is an important element because if you perform as a production operator or an independent contractor a workplace exam in a specific area, and then the other company's employees are coming in to perform either another task or assist in that task, they need to be notified of any adverse conditions which were observed and not corrected. So this is an element that is an important distinction in that now we can't just do the exam and put it away and anyone who wants can come in and out of this area all day. You have the requirement that anyone entering that specific work area must be made aware and notified of those conditions prior to entering the area or being exposed to them. So this is a situation where it's going to cross company lines. That is my assumption based off of how the rule is written and how I expect enforcement to take place. But that is, I think, going to be an issue that is experienced at least semi-frequently at the beginning of its enforcement, where one party was provided the information but not the other. Again, the requirements for the record have increased slightly. You have to make those available at the end or to the minor reps now, in addition to the MSHA inspectors. You have to include a bit of information in terms of the adverse conditions as well as the date the corrective action was taken. In terms of areas covered, there was clarification provided, but anywhere where extraction and milling processes are taking place, including the haul roads used to access those areas, isolated or abandoned areas don't have to be inspected unless work is going to be performed there that shift, and then it must be completed prior to. Excluded areas specifically are listed. They're pretty straightforward, but admin buildings and parking lots are a big issue or a big concern that aren't going to be included in this, as well as inactive storage areas. Again, if you're going to be in areas that are isolated or abandoned, you just need to make sure that the inspection takes place before you go into that area. Another element that frequently gets brought up when working with contractors, especially when it comes to being issued citations, is the walk-around right, because so many contractors feel they didn't have the opportunity to be with the inspector at the time of the inspection. You have, as a contractor, the same rights as a production operator to accompany the inspector. The reason this is typically an issue is because the contractors aren't notified when MSHA gets on site. So what I would say is you need to make it abundantly clear to production operator that you want to be involved in that process. And the production operator will then have that knowledge and be able to notify a specific person from the contractor when MSHA gets on site. That will allow you to exercise your rights to the opening conference, closing conference, etc. You might have an issue where a citation is dropped off and not received by the contractor. If you are the contractor, you need to make sure that any citations are received promptly from MSHA. They should be provided to your representative on site or mailed directly to your office. Sometimes they get left with the production operator, and then you see a week go by and the production operator gives that document back over. You want to make sure that MSHA has the means to get you that information, because your deadlines for formal and informal contest won't change while you're going through there or while you're waiting to receive that citation if it's been issued. Again, we're talking about responsibility. For Part 46 purposes, it falls on the production operator, has primary responsibility for site-specific, and there's also the requirement that the production operator must provide that information for the contractor to comply. It is also for new miner training and those purposes. The primary responsibility falls on the independent contractor. However, again, we see the word primary responsibility. That must trigger something for us that there is a secondary responsibility, and that falls on the production operator or the independent contractor, depending on what instance you're looking at. Also, the contractor has a duty to inform the production operator of any specific hazard that will be created by the contractor's work at the mine. Again, this is straightforward, but a list of those persons that have to receive site-specific hazard awareness training, and we'll just sum it up. That is everybody that comes on site. Site-specific has to be provided to everybody. Now, the level of site-specific can obviously change, and that's what Part C looks at. When we're talking about having maybe a bit more information for people that are specifically involved in the mining process, but those people are also probably going to be qualifying as miners. Site Section D gives us the ability to provide site-specific a couple ways in Part 46 sites, or it gives us what we have to cover, in those circumstances, and it's pretty straightforward. It lists it, so we just want to make sure that that is covered either in a form they sign when they get on site. It can be through signage. I think this is a good option, but also an option where we lack documentation that it was read. So be appropriate or be aware of that. The last portion of this is Section F, and it is an exception if you are accompanied at all times by an experienced miner who's familiar with the hazards specific to the site. I say that this is one that should not be used regularly just because the application is that person who has not received site-specific training must be mere feet away from the experienced miner at all times. So I think one of the best elements is a quick video, a quick form that is signed when they come on site. There is no specific requirement that this be provided or completed at certain intervals. MSHA likes to see it on a year, and that's because that's what the requirement on hazard training is for Part 48. But that is not specifically written in any of MSHA's information or regulations. So that's a best practice that the agency wants you to perform. What you do need to do is provide new site-specific hazard awareness training when the conditions on site have changed in a material fashion to the information contained in that training. So not a specific time frame, just when changes have taken place. And that might be a change such as your traffic pattern is a normal option or a normal condition triggering that. For the purposes of Part 48, we see again that there is a bit of distinction between who has responsibility. Per the program policy, Each operator is responsible for complying with all applicable provisions. Again, that operator is independent contractor and production operator, but you're seeing that it is a crossover. In terms of independent contractors are responsible for Part 48 training of their employees, and they may have their own plan or they may utilize the mine operator's plan. Again, that is going to be mine specific, and so you need to make sure that you have approval to use that plan if you're going to do so for production operator's plan. Again, I think this is more common in Part 48 where you have a contractor coming on site where there's an approved plan. But nonetheless, I don't necessarily recommend it. I think if you're a contractor frequently working in those areas, you should have your own plan. In terms of hazard training, under Part 48, they state that it must be tailored to fit the training needs of the particular contractor, meaning that not all independent contractors might get the same hazard training. And in doing so, you're looking at a number of different qualifications, whether what work is being done, where that work is being done, what hazards are going to be exposed to. But nonetheless, hazard training is a requirement throughout that process. And if we're looking at underground hazard training, it is going to include a good bit more information than the hazard training for Part 46. As I talked about before, there is the clause that it at least every 12 months, so there is a requirement that you have to complete it again. Hazard training is going to be required, as we talked about before, for anyone coming on site. It is going to have some basic elements, but again will be tailored to what task they are completing. But again, hazard recognition and avoidance, emergency and evacuation, health and safety standards and work procedures. Also in underground, we're talking about the use of self-rescue and respiratory. So amongst other things, it is the basic information for operating at that mine site. If we're looking at surface mine or surface operations of an underground mine, it is again a little bit different. You don't have as much description or detail in the training that is required for the self-rescue and respiratory, but it still has the clause that has to be provided at least once every 12 months. So there is a bit of a change between the three. Again, if you are looking at this from the perspective of an independent contractor or production operator, it has to be provided at every site. Just because your company might work at or own multiple operations and use the same contractor at multiple operations, each person must provide the hazard training at each site. And again, for the purposes of Part 48, it must be provided at least once every 12 months at each site. So one case that I want to bring up is a case where we had an evaluation of both the frequent and extended period of times, as well as a contractor being on site, and whether there was liability for a production operator in that circumstance when new miner training wasn't provided or completed. So in Ashgrove Cement, a case from 2015, and I think it was actually litigated quite a bit after that, but it was docketed in 2015, you had several questions, whether or not environmental cleanup workers were miners under the Act, which is the analysis of frequent or extended periods of time and exposure to mine hazards, and as well as whether a production operator was liable for a contract electrician failing to have all their new miner training. And then the follow-up to that is whether extraordinary circumstances existed to cite an operator or production operator for lack of training on a contractor. So to give a quick overview, the cleanup workers were on site to clean up an oil spill or a hydraulic oil spill. The argument was made that they were not required to have miner training because they were not on site for frequent or extended periods of time, nor were they involved in any mining operations. And what the judge eventually had decided in that circumstance was, even though this company employing the environmental cleanup workers had been on site previously and had contracted with this company on multiple occasions, the individuals had not been on site for a frequent or extended period of time, meaning they had not been on site repeatedly and they had not been there for 5 consecutive days. And in finding so, the judge determined they were not minors for training reasons. Additionally, mine had a contract electrician on site, a contractor, and one of the electricians had not received all of their required new minor training. As such, MSHA issued a citation to not only the contractor for lack of training, but also the production operator. And the production operator argued a clause from the program policy that in order for MSHA to issue a training citation to a production operator, there must be extraordinary circumstances present. And in arguing that those circumstances were not present, the production operator detailed their pre-qualification and monitoring process for independent contractor training, which meant reviewing training plans before they came on site, reviewing training records, inviting the independent contractor to come and satisfy some of their training plan requirements at the same time that a third party was providing training to the production operator's employees. So in doing so and putting all these reasons out there that they had essentially acted in good faith and taken precautions to ensure that safety and health and training was provided, the judge found that the production operator had satisfied their burden and that MSHA did not have adequate reason to cite them for this lack of training for one specific individual when the contractor had demonstrated the ability to properly train and keep up with training of their employees. So an interesting case, but nonetheless it shows that this is a situation that is still evaluated on a case-by-case basis as we discussed. Another citation that was interesting in that it was issued for a parking brake violation for a contractor at a mine site, and it was very easily could have been also issued to the production operator, but in this case it was not. And the reason this is an interesting one for our purposes now is because for a contractor, you're not always on site with your employees. You don't always have the ability to monitor what they're doing on a daily basis. And in this case, the independent contractor had argued that this citation should be vacated because they had provided training to the individual on parking their vehicle properly and engaging the parking brake. They had a procedure about doing so. They had taken they had taken the time to train on it and make sure that this was communicated. They had an enforcement procedure in place on people disobeying safety and health policies. And when all that was taken into consideration, the judge decided that there was no negligence on behalf of the contractor. And that was because the company was not aware of the failure to set it. But it also reinforces what we talked about before with strict liability. Despite them not knowing about it, despite them taking all these actions to prevent it, it occurred and the citation was issued and it was upheld. So two quick cases that I think kind of touch on some of the themes from the webinar today. In sum, I think that some of the crucial elements in interacting with and managing the relationship between production operator and independent contractor is being forthright and outlining the duties and responsibilities of both parties at the beginning. Know and make very clear, if you're a production operator, what you expect of your independent contractor when they're on site in terms of adhering to local safety and health procedures or requirements, as well as compliance with all MSHA regulations. Ensure that training programs are reviewed and training records are up to date to the extent possible, and that you make it very clear that those requirements must be upheld throughout the life of the contract, whatever that might be. And that includes not only the training, but also we're talking about Part 50 earlier, if those individuals or if the companies satisfy the requirements of needing to follow those, which again, any injury would have to be submitted to MSHA, but if you are a contractor who is in those professions where it's required to have a contractor ID, there's additional requirements on that. If you're a production operator, you want to enforce your site policies, as well as even consider a discipline program for contractors who fail to comply with them. And then again, establish an easy call tree or point person for each contractor so that there is not a confusion about who needs to contact who. This is especially important in the instance of a serious injury where there is the 15-minute reporting requirement, and lay it out beforehand which party is responsible for calling. I know a lot of large operations have their own on-site first responders, so contractors are required to call the production operator, who gets the first responders and then calls the emergency services and MSHA. But you want to make sure that there isn't any confusion there, because if MSHA comes out and an incident wasn't called in with that 15 minutes, the minimum fine is above $5,000 now, and someone will receive it. And if you can put forth, a document that says that was the contractor's responsibility, or if you're the contractor and you can put forth a document that says we were to report everything to the production operator and then they call MSHA, that can help alleviate that question, and also it just kind of goes and reinforces that communication needs to be established, who contacts who and at what time. And the same goes with the MSHA inspection and operators and contractors getting to exercise their walk-around rights. So I appreciate you all bearing with me. I know that was a lot of information today, and you will get a copy of the webinar and the slides to go through in more detail if you want. As always, please check out the blog for some review of recent cases. Just put up one that was a follow-up on the Commission's decision in the Sims Crane spreader bar case, which talks about MSHA's regulations on working beneath a suspended load. Also, our last webinar of 2018 will be in November, and we'll be discussing unwarrantable failures and how those affect our worksite and what they mean for us as an operator moving forward, whether we're a contractor or a production operator. So, with that, I will open it up to questions, and if you would like to or prefer to reach out to me afterwards directly to ask about any questions, that's fine. I'll also say after the webinar, you'll get prompted to go through a review or a survey. We're getting to the point where we're starting to, I'm looking to put together my itinerary and my schedule for next year's webinars. If there's a topic that you would like to hear about, please put it in a review and a survey, and I'll consider it for inclusion in next year's webinar series. So thank you very much, and I appreciate you all logging on today.